I just finished one book, which is called Global Antitrust and Sustainability. It's about enforcement, economics, and law. That's going to come up with OUP, and I've also finished an edited volume. It's a research handbook on sustainability and competition, which comes up with Edward Elgar. I have, I think, 30 contributors to that book. So all that, just to say, this is my topic, and I'll start off with a little practical example. So what am I talking about when I talk about sustainability and competition law and policy? Well, there's, for example, the Indonesian palm oil pledge that is from 2014 at the United Nations Climate Summit. The main producers of palm oil, you see the names here, they agreed not to buy palm oil anymore from newly deforested lands, in particular from Indonesia. And the competition authority didn't see any problems with this idea at the beginning, and the Association of Smallholders also said, oh, that's actually a good idea, we protect the forest, and they buy only from legitimate sources of palm oil. That's a good point. The political situation changed then slightly, and apparently there was pressure behind the scenes on the competition authority, and the competition authority then changed their view and said, oh, this is actually really bad for competition. This excludes smallholders, even though the Association of Smallholders previously had said, no, this is actually good. But they said it excludes smallholders because they are relying on cutting down the forest and planting these trees. After that, there was no formal decision, but when the competition authority raised issues, these companies abandoned this standard. What happened then was also interesting. The standard was basically copied and pasted from this private standard into the law in Indonesia. So now we have a law that basically is the same as this private standard. I have talked to friends in Indonesia, and they tell me to what extent this is enforced in reality is a different question. There's a saying that you could possibly say, what stays in the jungle, what happens in the jungle stays in the jungle. So what happens somewhere out there, no one knows. And I think it already kind of gives you a bit of an interesting touch, this example, where you have these kind of private initiatives, you can possibly have state initiatives, you have questions, what is enforced, what is not enforced, who should make these decisions, and those are all things that do come in to this debate here. But there are also other examples, and I'll just give you a couple of headlines. There was a famous case also around the same time, 2018-19, where Trump had this idea that there was a standard for emissions in the United States for cars, and the Environmental Protection Agency essentially set a minimum standard, but member states in the United States were allowed to set a higher standard. Trump then changed that standard to lower the federal standard and wanted to prohibit states from setting higher standards in order to have a lower environmental emission standards for cars across the US. Then some of the car makers actually agreed to all voluntarily comply with the standard that was set by California, which was higher than the federal standard. And the Department of Justice started an antitrust investigation into these standards, and then in the end dropped this because they thought like maybe there's a state action defense, but we can talk about this later. So that's another example, but there are tons more. I'll have here some. Volvo, BMW, Google say they're not going to take ocean minerals in their supply chain. There was a famous letter by BlackRock to all heads of companies to look into how they comply with the net emission targets. There's the European truck makers that say we're going to phase out diesels earlier than we are actually required to. There's even Glencore, which is a famous mining company, which has a lot of issues around it, has agreed to some kind of compact in the Democratic Republic of Congo. And there is two other things that I wanted to quickly highlight, which is this one, which is Climate 100 Action, 100 Plus Action Group, which is banks essentially and finance institutions. And you have here the number, what is it? 700 plus investors, over 68 trillion, 170 companies. They're all saying they want to do something about achieving net zero. And we'll come back to that one. And there are cases, for example, and I'll come back to this one as well, the car emissions cartel in the European Union that has been found. So that's a bit of the background. So what are we going to do today? So I start with a disclaimer, a small one, and then I'll talk a bit about why should we take into account sustainability in competition law and how that is. Then a quick overview about what sustainability is, a quick overview about EU competition law, because not everyone has studied it, and then law and economics of sustainability and competition law, and then actually substantive competition law with a bit of a focus on the EU with substantive and procedural aspects. So a lot that we have an hour, still 40 minutes. So the disclaimer, that was actually interesting. We say apples and oranges, and we can compare that. Yesterday, we had a nice walk with Ito-san, and we have talked about this. Competition lawyers quite often do comparative work, but we don't think so much about comparative work. And to what extent we can compare apples and oranges? Well, they're both fruits, right? But then they are not the same. So we need to be a bit mindful of that. In this regard, my work here and the book as well is not so much in detail. It's more about fruits in general than it is about apples and oranges, and to what extent we can compare them. It's just like setting out, we have this fruit and we have that fruit, and whatever fruit you want to choose is up to you. But we can talk about to what extent we can think about ways how we should do comparative competition. I think we do not think about this enough, and I'm guilty of this in this work, I think, as well. Okay, so then the normative question: should we take into account, care about sustainability in competition law? And I think that's there can be a lot of arguments, general arguments, concerns, and so on, which are that's the moral imperative. We should be concerned about this. We can, on the other hand, be concerned that this is a value judgment. Should it be competition or should it be sustainability? That's a value judgment, and competition agencies institutionally don't have the expertise to do that. So those are, I think, the kind of general concerns they might have. It's a political choice what you prefer over the two, and that's also, again, competition authorities should not be doing that. And I think those arguments are important arguments for the background, because they explain us a bit how you might see that. But I think those are questions and concerns that are a bit in the background. They do not necessarily come directly into play. They might just form background arguments. I think if we ask that question, and I think like the majority of you guys also online and here in the room, we are all lawyers, right? So if we want to answer a normative question, which is a question, should we not, we look at the law and look what the law answer that the law gives us. And we might be influenced by these kind of moral general arguments and concerns, but we first and all look into the law. And there the answer is rather simple, because the lawyers always say the same thing. They always say, it depends. It depends. And what does it depend? It depends on a lot of different things. For example, it depends on international law. Maybe international law requires you to look into sustainability. I don't know about Japan, and you can tell me later, but in general, we can distinguish between monist countries and dualist countries. Those are two different forms how international law is incorporated into national law, dualist countries, they need some kind of additional act before it becomes binding within a jurisdiction, while the Netherlands, for example, is a famous example of a monist country. As soon as they sign an international treaty, it's binding in the state and the courts can rely on it. So that it might be something that helps us in answering this question. There might be constitutional obligations imposed. I mentioned at the beginning Article 11 in the EU, Article 39 is a charter of the EU. You have something in the Constitution of Switzerland, of Mexico, in the Russian Constitution, in Ecuador. I just included Ecuador, I think this week actually, into the book. I send it back because in Ecuador, the nature has rights itself. So the nature itself has a right like a human being, and the state needs to protect that right and needs to respect that right. So if you are in a country like Ecuador, the answer might be rather different than if you are, for example, the United States. And the aims and provisions of the competition might also be different in different countries, and they help you as well in answering that question. So, as I said, it depends. Okay, so what is sustainability is the next question. The basic ideas is simple. There are 3 different ways how you can do that, but I always think it started off with the environment, and that's how I started off, where you say, well, we're living here on a planet, and the planet has certain limitations to it. It has only so much water, it only has so much fresh air, and we can only pollute so much. At some point, it's going to create problems. That was the start also of the sustainability debate, and they realized later in the 80s onwards that, well, focusing only on the environment is not good enough. Because if I want to protect let's say the forest, what do I do with the people? The people cut the forest down. Why do they cut the forest down? Because they are poor. They need the wood to burn, make fire and cook and eat. So there is a social element. Poverty will lead to environmental destruction. And poverty then is related to economic development. So that's how you basically bring together the environmental, the social, and the economic all together in one, and then you have a different one. So these 3 elements together form the idea of sustainability. And sustainability also exists then, and I think that's also important in the context. We talk sometimes about the sustainability agenda at the UN, goals 2030 agenda, but it's actually a UN resolution. It's a resolution 70/1, which sets out 17 development goals and 169 associated targets. This is relates from climate change to poverty reduction and so on. So that gives you a bit something in your hand if you think about what it means. And so we have a bit of an idea about sustainability. So if we now want to look what it can mean in competition law, then I think that's what I did later in my book, and I think it's still helpful. You can think about 2 ways about the integrating sustainability concerns into competition law. One is what I call supportive integration, where you support or let companies be more sustainable, and you're trying to step out of the way. You let them do what they want to do because it is good for the environment or it's good for sustainability. And then you have the other one, where you have what I called back then preventative integration, where you prevent an a behavior that is not beneficial but is detrimental to sustainability. So an unsustainable business practice, for example, is prevented using competition law. My colleague Simon Holmes has used the sword and the shield metaphor. So sword being where you use competition law to attack unsustainable business practices, and the shield to protect yourself from attacks from competition law. might be a very nice way as well to think about this. Slightly different, one more focus on the outcome, one more focus on the process, but it doesn't matter. I think we can use that. It's actually a much nicer metaphor and gets you to think about it in a nice structured way. And I'll use that metaphor as well to first look a bit into the sword, and then we'll talk about the shield, because the shield, and that's why supportive integration is a thick one on this thing, because this is where the debate is happening, where we are talking a lot about, and a lot of things are happening in this area. Okay. So now coming back to competition law, and now some of you have studied EU competition law, so that's not new. We have the rules on anti-competitive coordinated conduct in Article 101 TFEU, and then we have unilateral practices, abusive practices in Article 102 TFEU. Then we have a number of exceptions in Article 101 and 102, but we also have special exceptions in Article 106 too. We'll not talk about that so much today, but that's also something to take into account as well. That article relates to undertakings that have what is called? It's called services of general economic interest. So if an undertaking has the task or has been tasked with a service of general economic interest, then competition law doesn't apply in the same way as it does to other undertakings. And then we do have merger rules. For some reason it jumped. We have merger rules, and we're not going to focus too much on them either, but they play in the background, and you'll mention them here and there as well. Okay, so what are, if we say the action between competition law and sustainability is also dependent on the aims of competition law, we can then think about what are the aims of competition law in Japan, in Europe, or in other jurisdictions. And we had an interesting discussion about that yesterday. I heard that in Japan it's some kind of public interest, which then is not so 100% clear. Protection of consumers is also something that is in there. So in a sense, it relates to this question: is there a single overall aim that is maybe consumer welfare, or is consumer welfare one of the aims of competition law? Certainly, there's something that is nearly in all competition laws one important aim: consumer welfare. And if consumer welfare is an important thing, if we are thinking about sustainability in the context of competition law, does it then maybe dilute the idea of consumer welfare? Does it, maybe if we are introducing another goal, it makes things too complicated, because we suddenly need to balance between consumer welfare and sustainability and so on. And then the argument that I said is in the background comes back in, where we say, well, maybe it's not the task of the competition authority or the judges to balance sustainability and competition law. But then that also depends, I suppose, on the legal framework. So that, I think, gives you a bit of a feeling again about the debates. If we now move on and say, okay, so consumer welfare is important. Consumer welfare also helps us, or thinking about consumer welfare is related to how we think about economics, efficiency, and so on. Then we can think about how does economics, competition, relate to sustainability. And that's actually, sometimes it does, it's very helpful that it jumps ahead, sometimes it's too fast for me, but now it worked. So it overlapped. So it overlaps. You have an overlap certainly between sustainability and efficiency in form of resource efficiency. That is productive efficiency. In a sense, using less to produce the same amount is sustainable, and that is also efficient. And then the same overlap can also exist in terms of dynamic efficiency and sustainable innovation to improve the status quo in terms of sustainability. You might say sustainability innovation. We are having green innovation. That's the kind of overlap as well. So they work pretty much in the same way. Overall, competition lawyers and economists, I think they do agree that our starting movement is always sustainability. Well, maybe regulation is the way forward. That's the best way to achieve sustainability. But as I said at the beginning, if you think about this case from Indonesia, well, maybe that's the best way to do it from a theoretical point of view. Whether it's practically the best way, that's a different one. If we then look into the economic studies and think about what do they tell us about economics and competition and markets and sustainability, there are not that many studies. I've tried to collect all of them, or the vast majority of them, in my book, and essentially it's again a lawyer's answer. It depends, but there is a very nice way of putting it, where Martin-Peter Schinkel has shown that if consumers care about sustainability, then competition should deliver it to us. It's essentially the same as a quality argument, right? Quality is a parameter of competition, and then companies compete about quality, and those with a higher quality will attract the consumers, and then the other one wants to maybe improve even further the quality. And if quality is a parameter of sustainability, can be a quality parameter, then competition should lead to better sustainability outcomes. And that's something very clear, I suppose, that quality is, or sustainability can be a quality parameter. The question, however, is the willingness to pay. So how much are you willing to pay for this bottle of water if it is sustainably produced versus another bottle that looks exactly the same and that is not sustainably produced? And that's something which we can measure, but we will always be subject, or not always, but quite often consumers are subject to biases and then need to be taken into account when we're trying to measure that. Overall, we can say if competition and sustainability have an overlap between this idea of innovation and competition, then maybe we can compare it to innovation in general and say there is this inverted U shape that exists. So a lot of competition will be bad for innovation. No competition will also be bad for innovation. If a bit of competition exists, that's not too much and not too little. That's where the best, what is the best in terms of innovation, and that might be then also the best for sustainability purposes. Okay, so now we move on, and let's talk back about the sword and the shield. And first, we're going to focus on the sword, kind of the situation where you use sustainability to attack unsustainable business practices, to attack practices that harm competition and sustainability. But I think I'll just pause here and give the opportunity to ask questions. Should we take away? Should we take account into sustainability? We had a brief overview about sustainability, and then we talked about the law and economics of sustainability and competition, and the sword and the shield kind of distinction. Are there any questions, comments so far? No? No?
No. The aim of the competition law and this relationship between the sustainability. But do you think that sustainability is something independent from the, for example, condition of trade, or it's just a part of the condition of trade?
Is it? Yes, that's a very good question. Is sustainability something independent of the conditions of trade, or is it part of it? I think it's both. Both. For me, it's the question of an overlap. So if I have this, I had this Venn diagram, but my wife told me it's not needed. You can just say it's a Venn diagram. So you have on the one hand sustainability, and on the other hand you can have consumer welfare, or in your case, the conditions of trade. And sometimes they overlap on a certain extent. It depends really how much they overlap. And sometimes they overlap a lot, but there are also elements that don't overlap. So then in those areas where they don't overlap, then they are not conditions of trade. And then when they overlap, then they are conditions of trade. Then it's a quality parameter, for example. So it is in that sense an overlap sometimes and sometimes not. So I think that's something that is also an interesting question, because when I started my study in sustainability and back in the days environmental protection and competition law, when I first said to an American scholar, and it is a very progressive scholar, that I'm doing environmental protection and competition law, the answer was, oh, but they don't have anything to do with each other. It's either environmental protection or competition law. Or are you looking into how environmental protection laws badly affect competition? So the other way, so I think moving away from the either or question and trying to look into where is this overlap, I think that's where my work focuses on, and I think that's where we need to focus on. And then we can think about, when we have this overlap, how do we deal with this overlap, and how do we deal with the areas that don't overlap? And sometimes you can deal that nicely, and sometimes not so nicely. And we'll come to that. Thanks. Questions online? Okay, then I'll continue here, and we'll move on into the actual substantive competition law question. So the sword situation, where maintaining competition fosters sustainability. Competition, in a sense, law is used as a sword in the struggle to prevent unsustainable business practices. And I think we can think here about different elements, and it gets more and more controversial. An easy common ground are mergers. We have seen cases in mergers where reducing competition in relevant industries might be problematic from a sustainability perspective. There's a case in the United States about batteries. So if you have no competition in the batteries market, you might see, well, this is bad for competition in the batteries market, but it's also bad for renewable energies, because we might need battery storage, and it's important that we see innovation and competition in this area. We even have a case in France. It's a hardwood flooring case. That was a cartel case where those companies were all producing hardwood floor, different ways how you can have floor in your houses, but they agreed to say, well, we're not going to announce how our products perform in terms of the environmental performance. So we're not going to compete over who has the better environmentally sustainable product. We're just going to compete on price. No one mentions ever sustainability in their marketing tools. That was the cartel that the French prosecuted. So that's still kind of more or less common ground, traditional situations. It then gets, you can start to push the boundaries a bit. You can think about, we already said that sustainability might be an innovation-related problem. So innovation theories of harm. We have seen that in cartels. The EU Commission, that was the picture that I had, was the cartel in the emissions cartel, I think they called it. That was in the EU. The producers, that was, I think, BMW, Mercedes-Benz, basically all the famous European cars, they all got together and agreed on a standard on AdBlue. AdBlue is an additive to diesel cars that reduces the emissions from diesel cars. But what they also agreed is not to further innovate in that area. Just keep that standard and don't compete anymore on better innovations in that area. And the Commission thought that was a cartel. What is interesting in that sense is it's the first time that the Commission has pursued a theory of harm purely based on innovation theory. They didn't say, well, this is going to lead to higher prices. Previously, they said, oh, you're restricting innovation and this will lead to higher prices. Well, in this case, they said, no, it's enough that you are restricting competition here in terms of innovation, and that's our theory of harm, and that's a cartel. End of story. It goes back to where we saw it the first time was Bayer Monsanto, where they said, well, here we have different innovation spaces. There are also some that are innovation spaces related to sustainability, and we need to protect them itself, even though they don't lead directly to increases in price. We just look at innovation itself or sustainability innovation in those two cases. So that's, I think, in that sense, pushing the boundary, because you have a separate theory that is only based on innovation, on sustainability innovation in this case, and not on price increases as a result of the missing innovation. We can then possibly push the boundaries even further. We can talk, for example, if we go back to Bayer Monsanto, there were people that said, well, you did not take into account innovation diversity. What do I mean by innovation diversity? So those are things you say, well, I have the problem, Bayer Monsanto, that let's say pesticides or insecticides. We have a pest, an insect that attacks these plants that we want to protect. And Bayer and Monsanto, they are very focused on using chemicals to fight this insect. But there are other ways to fight that insect. For example, using other insects that are also might fly out and kill that insect. So now you should take into account that different pathways might lead to addressing this problem. And if you are concerned that they are shutting down different pathways, then that should be a separate theory of harm. And that's a bit kind of hasn't happened. We haven't seen that the innovation diversity point, because there are different pathways to innovation. So we haven't seen that. Same could possibly be with exploitative practices, abuses, where you say, well, this is abusive towards the farmers, poverty, situations like this. I think countries which have, I think Japan has also a relative bargaining power questions. I think there you can possibly use that in a much more targeted way if you have problems with people abusing their power against poor people or farmers or so on in the supply chain. You could possibly do that. So that's, I think, if we talk about the sword and where you use competition law to foster sustainability. Are there any kind of thoughts on that question? We can also use it later, but I always kind of like to open the floor quickly, because it is so many different things. Good. Then we can come back later. That leads me to the next point, which is the competition, the shield kind of question. The obstacle, is competition law an obstacle, and how do we deal with this? Is that a case, for example, that I mentioned right at the beginning, the palm oil pledge? So I think the question that we can ask here is, do we balance or do we not balance? Do we balance sustainability and competition, or don't we need to do this? What do I mean by this? I think it's important in this debate to remember that is something within the scope of competition law, or is it not? Why is that? Because not every restriction on commercial freedom is always a restriction of competition. Because otherwise every contract is a restriction of competition, and that cannot be. So different countries deal with this kind of question, what is within the scope of competition, no differently. And I'll have a couple of examples later, but first we basically need to ask ourselves, are we within the scope of competition law? And then we can say like, okay, we are going to balance now sustainability versus the restriction of competition. And then the question is, how do we balance this? And this is where it's sometimes very controversial. How do we balance this, depending on the jurisdiction? Okay, so what is not within the scope? We know that, for example, in some countries like the EU, I don't know how it is in Japan, but you can tell me later. Certain it's only commercial or economic activities which are within the scope of competition law. So there was, for example, a case in the EU where NGOs, environmental non-profit companies were charged with looking after a forest, which was a national protected forest, and they were basically said, oh, you need to look after this forest, and you're also allowed to give hunting licenses or whatever, fishing licenses and so on, but you need to protect it. So is that an economic activity? Is it not? Questions like this, you might ask questions here. You have sectoral exemptions. For example, in the agriculture, in the EU and the US, the US has completely excluded competition law there. The EU has now a new sectorial regime for competition law in the agricultural sector, and there it also specifically addresses sustainability. So if you're saying doing something in the agricultural area and restricting competition for sustainability purposes, that seems to be okay there. So then it's not within competition law. You have the state action, state compulsion situation. That's the US car case. The argument here is that the state set the standard. It was California that set the standard and therefore was in charge of the standard, and it was only the companies that pledged to comply with it. So they didn't set the standard. In the EU, it works slightly different. In the EU, if the state forces you to act in a certain way, then it's not within the within competition law. But if you have some kind of leeway on deciding how to act, then it's not within the scope. Then it is within the scope of competition law. Then you have a number of cases where you say, well, there is no restriction of competition. In the EU, you have so-called loose commitments where companies, there was a case with the Japanese car association in the 90s that said, we're going to agree, that was already in the 90s, all to aim to reduce our emissions by 2010 by 10% or something like that. But how they're going to do that, each individual company was left to competition. It was just that we all are going to reduce it by 10%. How is up to it. They can reduce the weight of the car, they can improve the efficiency of the engines. So that is left to competition. So that's not a restriction of competition. We had something similar with yogurt packaging in the UK, or the Netherlands now in their draft guidelines said, and the EU in a slightly different way as well. If you are complying with laws, you make an agreement where you say, well, we're going to comply with the laws in the Philippines on deforestation. That's not a restriction of competition. And then lastly, and I'll talk a bit more about this because I know that there's someone in here who's interested in that, standard setting. Standard setting, if you comply with certain requirements, then you have, for example, in the EU, you have a soft safe harbor. The new Japanese guidelines mention 5 areas. If you do not restrict them, then there's also no restriction of competition, and we'll talk about that. So, for example, in the EU, if you have an environmental sustainability standard that distinguish sustainability standards from technical standards, they say you need to have, first of all, open and transparent procedures in developing the standards. Then you need to have no direct or indirect obligation on other undertakings who do not wish to comply with the standard to comply. So only those that sign up for the standard need to comply. Everyone else, there's no requirement to do so. It can be binding on the people that are part of the standard. So you can, for example, tell them, like, if you don't comply with our standard, then we kick you out. But you cannot kick them out if they offer a higher standard. So if they go beyond what the standard set, that needs to be possible. You can prevent companies from doing that. So competition towards higher standards is possible, and then you need to be non-discriminatory in terms of access. Everyone that fulfills the conditions is able to get the benefits of the standard. And then you need to have at least one of the following two conditions. You either do not increase substantially the price or reduce the quality of the product, or your market share. If you increase the price substantially or reduce the quality substantially, but your market share is below 20%, then it's also fine. The JFTC guidelines say there is no effect on competition when, and it's rather similar in the sense it comes to the same outcome. There is no agreement on price. There is no exclusion of other specifications, so you can have other ways to achieve the same goal. There is no unreasonable expansion of the scope of the specifications of the standard. I think going not beyond what is necessary. You have no unreasonable exclusion of certain technology proposals. There's this kind of open, transparent, non-discriminatory proceedings kind of idea, and no restraints on the participation in the standardization activity. So that's the kind of, if you fulfill these conditions in Japan or the EU, then your sustainability standard is not restricting competition, so it's not within the scope of competition law. So you don't need to balance competition versus sustainability. Okay, but if we are now going to balancing, how does that work? I think we have two different forms of balancing. We can have what I call the abstract judicial balancing. That's here the judicial scale, and then you have more the economics scale, which is the more detailed measurement scale. And those are both, you can see them. For example, an abstract balancing is a public interest balancing, where you directly say, well, what's the benefit for sustainability? What's the harm for competition? And you say, well, we can do that this way. You have such kind of public interest balancing in Australia, in South Africa, and maybe in China. It's a bit kind of unclear how it works because the guidelines were not finally adopted. You have public interest clauses in mergers, for example, in Germany, in Spain, it specifically mentions in mergers environmental protections. And then we talked here yesterday about this. There is in EU law, there is a line of cases for horizontal cases in the context of Article 1011. Article 1011 says anti-competitive agreements are restricted, but the Wouters line of cases says under certain conditions, it's a bit kind of unclear what the conditions are. You can balance the public interest benefit and the restriction of competition. Wouters was an agreement or was the bar association which said you cannot have new kind of businesses where lawyers and accountants are together at the same time in an office. They need to be separate. And that was after the Enron scandal, where the accountants and the lawyers had worked so closely that the supervision of Enron was not really happening. So in that light, the Bar Association said we cannot have lawyers and accountants working in one company together. And the court said, yes, that's you are in charge of administering the course of justice. That's part what the law says, what the Bar Association's job is. And that might be a restriction of competition, but like overall, it's not a restriction within the meaning of Article 1011. So that's the kind of abstract balancing. But then you have the more kind of balancing that we quite often talk in competition law about, which is about 1013, economic benefits, consumer welfare. Different countries call that differently. Here, I suppose, going back to the economics, quality, innovation improvement is an easy one. If your product is improved in quality, you can apply that. You can then push the boundaries out and you say, so what are we going to do with future benefits and benefits that happen in other markets? There it gets a bit more difficult. Sometimes we can do that. Maybe we need to apply some kind of discount rates. But in particular, when we are looking into future benefits in other markets, then it gets really tricky. So maybe you can use broader efficiency measurements, where the Dutch have suggested contingent valuation. Shadow pricing was in the draft guidelines, but now they have adopted different things. The joint technical report had some propositions of that was done for the Dutch Competition Authority together with the Greek Competition Authority. And the European Commission now in its guidelines says we're going to look into use benefits. So what a user thinks in terms of quality, oh, this is a sustainable product, so this has a higher quality, that's a use benefit. But then there are so-called non-use benefits. We talked, Ito-san and I talked yesterday about this. What is a non-use benefit? The fact that there's a forest up on the hill, he does never go there, he never uses it. But he still appreciates the fact that there's a forest over there. And he would certainly be willing to spend some money to keep that forest. So that's a non-use benefit. And then you have collective societal benefits. So that could be, for example, reductions in CO2 emissions, and how you take them into account is much more complicated. The Commission says we're going to look and restrict the last one, the collective benefits, and only say we're going to only take into account the amount that is accrued to those people that have to pay the higher price of the affected market. So if you have a restriction in the market for cars, and you don't take all of the CO2 benefits into account, but only those consumers, those benefits that are also accrued to those, I don't know, let's assume 1 million car users. So you divide all the benefits that you have on a public scale and see how much of that accrued to those car users. So that's how you can try to push the boundaries a bit out. But the question, I think, and I'm going to try to wrap up, is also highlighted in this first case that I presented. So if you are having these companies that agree to not deforest the land in Indonesia, or you can make a case that European companies have an agreement that relates to let's say Thailand and the production of garment, and they're not going to pollute the river anymore in Thailand. What are the benefits for the European consumers? Okay, they might have use benefits and non-use benefits, but the collective benefits are not there. And what about this kind of idea that suddenly you have the companies in Europe determining what the standards are in Indonesia or Vietnam? Is that some kind of neo-colonialism where I said I don't let them decide for what's good for them? So there are these kind of questions. Essentially, you could say companies are imposing costs on one group, and they decide that these people should pay it, and then like another group benefits, and whether they want to benefit, we don't even consider that. So those are questions. They're difficult. Okay, so we have, and I'll just quickly jump. We have the European rule of reason. That's the kind of abstract balancing Wouters kind of situation. We have a number of cases which say an environmental improvement is an improvement of production under Article 101(3). Fair share of consumers. That's the kind of question if we talk about these plastics. But we have done that now a bit. Okay. So just very briefly, I think that was a substantive element. You can also talk about procedural elements, procedural matters, and in a sense, procedure matters in these cases. Why? Because we can have so many different questions. So you can have questions about agencies' objective enforcement priorities, targeted enforcement. The CMA, the Competition Authority in the UK, said we're going to have a case in our next 4 years. We're going to focus our case on the sustainable transition. We want to have cases in that area. We're going to look whether there is something. And they have done something, for example, with charging stations for cars. They have provided some advice. They have done a market study. So they're going to target the enforcement in those areas that are important for sustainability. You have guidance, the formal one, which the Japanese JFTC has done an amazing job. I think it's the most comprehensive guidance that we have seen on the topic across the world, but we have also seen other guidances. Openness to informal guidance, we have seen that as well. The Commission, for example, said, come to us, talk to us. Our door is open, which is a change of policy. They didn't have that before. You can have approval, exemption procedures. In Australia, you have that, for example. Sandboxing in Greece. Anyone heard of sandboxing? That's where you essentially go to the authority and you're playing like in a sandbox. They look over you and you constantly are supervised by them. So it's a constant form of supervision. You are allowed to play out and do whatever you like until they say, oh, no, stop hurting your colleague here. Don't stop that. And then you stop because you're in the sandbox. But it's fine if you do it because you're not going to get fined because you're in the sandbox under constant supervision. Comes from the area of financial supervision. Evidence, you might ask questions about what kind of evidence can you do in such matters, how can you assess that? Capacity, to what extent do you have expertise in the area? To what extent maybe can you get that by working with other regulators? The French, for example, have set up a team amongst the competition authority and other regulators to look into sustainability matters. Fining, the Netherlands, for example, said, if you follow our guidelines or talk to us and you do what we tell you, we're not going to fine you. If you've done that in good faith, you're not going to face a fine. So that, I think, is an important thing. Cooperation in the context of international organizations, also important that you don't get into problem. Okay, so that's it. Thank you. Questions, comments now, and always you can email me or see on Twitter. I'm not using that much anymore, but I'm still there. Okay, thank you.
Thank you. Thank you so much. Thank you. Yeah, typically you have to stop.
Yes, nice.
Screen.
That's a good one. Yeah.
Okay.
That's fine. So yeah, yes. Also we okay. This too.